Late one evening, a man locked the front door of his home, placed a handgun in a drawer beside his bed, and went to sleep believing he was doing something completely ordinary. In most of American history, that simple act would not have sparked a national debate, but by the early 2000s, the question of whether ordinary citizens had the legal right to keep a firearm in their own homes had quietly become one of the most contested constitutional questions in the country. For decades, courts across the United States had disagreed about what the Constitution actually meant when it said that the right of the people to keep and bear arms shall not be infringed. Did that sentence protect an individual right? Or was it connected only to organized militias and military service? For years, legal scholars argued, legislators debated, lower courts issued conflicting rulings, and then one case arrived at the highest court in the United States that would force the issue to be answered once and for all, a case that would reshape American gun law and ignite one of the most significant constitutional debates of the modern era. Before we dive into the story, think about this for a moment. If a constitutional right is written in the nation's founding document, who ultimately decides what that right truly means? Is it lawmakers? Is it the public? Or is it the courts interpreting the Constitution centuries later? Share your thoughts in the comments as we explore one of the most consequential Supreme Court decisions ever made about the Second Amendment. To understand how this moment unfolded, we need to go back much further than the courtroom where the decision was eventually announced. We need to go back to the late 18th century. When the United States Constitution was drafted in 1787, it created a framework for a new government, but many Americans worried that the document did not adequately protect individual liberties. In response to those concerns, the Bill of Rights was added. Ratified in 1791, the Bill of Rights included 10 amendments designed to protect certain freedoms from government interference. Among them was the Second Amendment. The amendment's wording is famously brief. It states that a well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. For generations, those 27 words sparked intense legal debate. Some historians argued that the amendment primarily protected the ability of states to maintain militias. Others believed the language clearly referred to an individual right possessed by ordinary citizens. For much of American history, however, the Supreme Court rarely addressed the issue directly. There were a few 19th century cases touching on firearms regulations, but none definitively answered the central question. Did the Second Amendment guarantee a personal right to own firearms for lawful purposes like self-defense? By the 20th century, federal and state governments had enacted numerous firearm regulations. Some laws restricted certain weapons. Others required permits or limited where firearms could be carried. Most of these laws were rarely challenged on constitutional grounds. Then, in the 1970s and 1980s, something began to change. Legal scholars started re-examining the historical meaning of the Second Amendment. New academic research began appearing in law journals, analyzing the language of the amendment, historical militia practices, and early American writings. At the same time, debates about crime, public safety, and gun ownership were becoming increasingly visible in American politics. As those debates intensified, questions about constitutional interpretation slowly moved from academic journals into courtrooms. Several lower federal courts issued rulings suggesting that the Second Amendment might indeed protect an individual right. Others reached the opposite conclusion. By the early 2000s, the country had a patchwork of legal interpretations. In some regions, courts treated the amendment as protecting individuals. In others, courts interpreted it more narrowly. Eventually, a case from Washington, D.C. would bring the issue directly before the Supreme Court. The District of Columbia had one of the strictest firearm laws in the United States. The law essentially prohibited residents from possessing handguns in their homes. Even firearms that were legally owned had to be stored unloaded and locked or disassembled. Supporters of the law argued that it was designed to reduce gun violence in the nation's capital. Critics argued that it prevented law-abiding citizens from defending themselves inside their own homes. Among those critics was a man named Dick Heller. Heller worked as a security officer in Washington, D.C., and he was authorized to carry a firearm while on duty. But when he tried to register a handgun for personal use at home, his application was denied under the district's gun control law. Believing the law violated his constitutional rights, Heller filed a lawsuit challenging the ban. The case slowly worked its way through the federal court system. At first, many observers did not expect it to become a historic constitutional battle. But as the case progressed, something unusual happened. The lower court ruled in Heller's favor. The decision stated that the Second Amendment protected an individual right to possess firearms. That ruling created a direct constitutional conflict with other federal court decisions, and when such conflicts arise, the Supreme Court often steps in to resolve them. In 2008, the court agreed to hear the case. The case would become known as District of Columbia versus Heller. Inside the courtroom, the justices were asked to confront a question that had lingered for more than 2 centuries. Did the Constitution protect an individual right to own a firearm for self-defense? Or did the Second Amendment apply only to organized militias? The arguments presented before the court were deeply rooted in history. Lawyers on both sides examined the language of the amendment, historical writings from the founding era, early American laws, and prior court decisions. The justices themselves asked probing questions during oral arguments. They examined the wording of the amendment line by line. What did the phrase, "the right of the people," mean? How should the reference to a well-regulated militia be interpreted? Was the militia clause meant to limit the right or explain one of its purposes? These questions were not easy to answer. Legal interpretation often requires balancing historical evidence, constitutional text, and modern legal principles. Months passed after the arguments. Then, on June 26, 2008, the Supreme Court released its decision. By a narrow 5-4 majority, the court ruled that the Second Amendment protects an individual right to possess firearms for lawful purposes such as self-defense within the home. Justice Antonin Scalia wrote the majority opinion. The decision carefully analyzed the amendment's language and historical context. The majority concluded that the phrase, "the right of the people," referred to an individual right, similar to other rights protected in the Bill of Rights. They also concluded that the militia clause explained one reason for the amendment, but did not limit the broader right. In other words, the court determined that the Constitution protects the ability of law-abiding citizens to possess firearms for lawful purposes. However, the ruling did not declare that all gun regulations were unconstitutional. In fact, the decision explicitly acknowledged that certain long-standing restrictions could still be valid. For example, the court noted that laws prohibiting firearm possession by felons or individuals with serious criminal histories were generally permissible. Restrictions on carrying firearms in sensitive places, such as schools or government buildings, were also mentioned as examples of potentially valid regulations. The decision focused specifically on the District of Columbia's handgun ban. The court ruled that a total prohibition on handguns inside the home violated the Second Amendment. It also ruled that requiring firearms to be kept inoperable at all times prevented lawful self-defense. As a result, the D.C. law was struck down. For the first time in American history, the Supreme Court had clearly stated that the Second Amendment protects an individual right to possess firearms for self-defense within the home. The ruling immediately became one of the most discussed constitutional decisions of the modern era. Supporters of the decision viewed it as a confirmation of a long-standing constitutional right. Critics worried that it could limit the ability of governments to enact certain gun regulations, but the legal story did not end there. At the time of the Heller decision, the ruling applied only to federal jurisdictions like Washington, D.C. It did not automatically apply to individual states. That question was addressed 2 years later in another Supreme Court case. In 2010, the court decided McDonald versus Chicago. This case examined whether the Second Amendment should apply to state and local governments through the 14th Amendment. Once again, the court ruled by a narrow majority. The justices concluded that the Second Amendment right recognized in Heller was indeed fundamental and therefore applied to the states. That meant state and local laws would also need to respect the constitutional right identified in the Heller decision. Together, these two rulings significantly reshaped the legal landscape surrounding firearms in the United States. But even after these landmark cases, courts across the country continued to grapple with how to interpret and apply the Second Amendment. Questions remained about which types of regulations were constitutional and which might violate the right recognized by the court. Over the years, numerous legal challenges have reached federal courts addressing issues such as public carry laws, licensing systems, and restrictions on certain types of firearms. Some of those cases eventually returned to the Supreme Court. In 2022, another major decision added a new chapter to the story. In New York State Rifle and Pistol Association versus Bruin, the court examined a New York law that required individuals to demonstrate a special need to carry a handgun in public. The court ruled that the law violated the Second Amendment. In doing so, the justices introduced a new legal framework for evaluating gun regulations. The court stated that firearm regulations should be evaluated by examining the nation's historical tradition of firearm regulation. This historical approach would guide future legal challenges involving the Second Amendment. For legal scholars, judges, and policymakers, these decisions have created an ongoing constitutional conversation. Courts continue to interpret how historical traditions apply to modern regulations. Legislatures continue to debate public safety measures, and citizens continue to discuss what the Second Amendment means in today's society. It is important to remember that constitutional interpretation often evolves over time. The Supreme Court does not write new laws in these cases. Instead, it interprets the meaning of the Constitution and determines how existing laws align with that interpretation. The decisions in Heller, MacDonald, and Bruin have each played a role in shaping the current legal understanding of gun rights in the United States. But the broader debate about firearm policy continues beyond the courtroom. Communities, lawmakers, legal scholars, and citizens all participate in that discussion, and as society changes, legal questions often return to the courts for further interpretation. So when people say that a Supreme Court decision changed gun laws forever, they are often referring to moments like the Heller ruling, moments when the court clarified the meaning of constitutional language written more than 2 centuries earlier, moments when a few paragraphs of legal reasoning reshaped decades of legal uncertainty, and moments when the interpretation of a single sentence in the Constitution continues to influence debates for generations. Now, I'm curious to hear your perspective. Do you think Supreme Court decisions should have such a powerful role in shaping constitutional rights? Or should those decisions be guided more by evolving laws passed by elected representatives? Share your thoughts and experiences in the comments. Because the story of constitutional law is not just about judges and courtrooms. It's also about the ongoing conversation between citizens, lawmakers, and the legal system about how rights should be understood in a changing world. And that conversation continues every day.